Viewers, welcome to the Personal Injury Law Show. This is a show that talks about everything current in the law of personal injuries and obviously of importance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer with 30 years experience. With me tonight I've got Nunzio Tartaglia, the partner in insurance law in the law firm. Good evening, Nunz.
Evening, Tony. Evening, viewers.
And Jess Rosla, a lawyer in insurance law at a law firm. Good evening, Jess.
Evening, Tony. Evening, viewers.
Tonight, viewers, are going to give you an update on insurance law. There's some very interesting cases, so stay tuned for that.
Before we kick off, Tony, what's in the news?
There's been a lot of stories, guys. The one that I want to start off with is Joe Hockey taking Fairfax Media to court on defamation. What happened with Joe Hockey is he won part of his claim but lost on substantive issues. The claim was for a significant amount of money. The court awarded him $200,000. Legal fees were in excess of $1.2 million, but the judge only awarded him 15% of his fees on a party-party basis. Nunz, what does that mean? There's a massive shortfall, isn't it?
That means he's out of pocket substantially, because generally when you do get what's called a party cost order, the other side generally pays for a majority of your legal fees, and there's only a small shortfall. But in this case,
it could be up to 40%.
But in this case, it's almost his whole. It's almost all a shortfall. So he's substantially out of pocket, Tony. It's a big lesson.
Oh, Jess, and the message we want to send to viewers is this: when your lawyers are talking about your cases and going to court, and you're saying that the settlement's too low. You've got to really listen, because you could win and still be out of pocket. Is that correct?
Yeah, that's exactly right, Tony. It's a perfect example of that time and time again case where the fees just outweigh the benefit of moving forward to court. So it's, I mean, whilst it's still a win, at the end of the day, what do you walk away with?
Well, it's a loss because you're out of pocket at least $300,000.
Yeah.
And that's also a lesson to viewers out there, because you go to court, you might get a jury to give you $300, and then you find that the shortfall in solicitor client costs could be $150 plus. So you really got to weigh it up. Whether you go to court and settle for, go to court and get a larger result but get less money in your hands, or settle for a lesser amount and get rid of all the risks and costs of litigation.
Yeah.
Anyway, we'll come back to a story. Salmonella at the Langham. Jess. This is a very interesting story.
It is, Tony. Have you dined at the Langham before?
I have.
Yeah,
the food's
beautiful
been pretty
restaurant.
good.
Yeah,
nice environment, great ambience.
Yeah, I mean, unfortunately for the customers who attended on, I think, the weekend of 11, 12 July, had a pretty unpleasant experience, Tony. About 44 people out of the 77 fell ill with salmonella.
And also, some time ago, they had a story that the Langham had been visited by the health department about issues they had a year ago. There are allegations, obviously.
Yeah.
Sure.
And Nunz, there's a suggestion that even though they visited the hotel, you can't publicise it. What's that all about?
Yeah, effectively there's laws that prohibit the publication of any findings unless there's a criminal prosecution against the hotel, and you know, there's arguments to say that there should be publicised so people and customers are aware of sort of what they're going into. Obviously, they're getting enough press now anyway that I think everyone's going to be a little bit careful going to Langham. But look, they're still investigating, I suppose, the source of the salmonella and how it's you know, how it's come to bear, but doesn't look good, because there's also been, I think, cockroaches they've found at some stage.
Well, they also talk about
allegedly
mice some time ago. But look, the thing I would have thought is if a health inspector's been to a location and they've made findings of fact, I don't know why you can't publicise those.
Yeah. Well, there was some suggestion that from the state government to the local government saying, well, you could potentially implement laws to publicise those findings, but for some reason they haven't.
Anyway, look, we'll get back to these sorts of stories. Nunz, tell us about this young work experience girl carrying a tray of drinks and seriously injuring her right arm. Yeah,
so this is the Langham once again. So they're in a bit of hot water at the moment. So she was just there on work experience, carrying a tray of alcoholic drinks and quite a few number of glasses, from what I understand. And obviously she's injured her arm in the course of doing so. But an interesting issue with this one is that she's a minor, but at the same time she was serving alcohol during work experience.
Jess, this issue about it's a work situation, so they still had to do a risk assessment, didn't they?
Yeah, you would think there'd at least be some kind of discussion about what duties would be appropriate for a minor, Tony, and certainly carrying a heavy tray of drinks or serving alcohol would have been definitely not on that list. So curious to find out as to how she was allocated those duties.
And Nunz, the fact that she was carrying liquor doesn't necessarily make it negligent. However, they still need to risk assess whether the duty she was doing were appropriate in the circumstances.
That's right. Look, I think that could be a red herring in the sense that you've got to basically prove what caused her injuries, and
Yes.
Serving liquor doesn't look like that was the case in point, but I suppose the facts will come to bear at some stage.
And you can't just say, here's a tray, go and carry the liquor. You've got to make sure that you've got weights and...
Some adequate training.
Yeah, you need some sort of training.
Yeah.
All right, the jailbreak that occurred recently, the Victorian government's out of pocket about $20 million. Nunz, there's a lot of people on stress leave now.
Yeah, so the issue is that majority of the staff, I think up to 120, haven't returned to work because they're, one, they're on stress leave, and two, they're worried about their safety. I'm not sure why they view the CCTV footage, but the workers did, and they're worried about how easily the inmates escape from their prison cells, and understandably they're afraid to go back to work, Tony, and it's a big issue because I don't know how you're going to eradicate it very quickly.
Jess, it's a bit strange that you've got people cutting loose like that in a prison environment.
Certainly, yeah. And it sounds like it was over a pretty innocuous cause. So I think there was a smoking ban introduced, and then the riot just unfolded, and I guess one thing led to another, and all of a sudden the people in charge were put at risk of their lives, I guess.
Tony, could there be some common law claims out of this?
I would have thought so.
On what basis?
Apparently the latest is that the authorities knew that there could be a situation like this.
Yep, so they're on notice.
They closed their mind to it. Also, it's reasonably foreseeable that if you have a riot like this, that people are going to be injured,
Yep.
Psychiatric or physical.
Yeah.
So
definitely.
I would have thought that, depending on how severe someone's injuries are, there could be claims flown from this in due course.
Yeah.
But look, we could always follow this up.
Look, I think we'll probably hear more about that.
All right, there's a fellow who fought the Morwell Blaze, a firefighter, who's now contracted cancer, and we've been, arguing this point for a long time, Nunz.
Yeah.
Yeah, it's similar to the Fistfield issue, and he's got leukemia, and he's argued that the chemical benzene, which was there at the Morwell fire, I think it was early or late last year or this year.
45-day fire.
Yeah, 45-day fire. That's the cause of his leukemia. So I think Mr Andrews' Labor government's opened an inquiry to see exactly what's gone down again. I think he has to, because the pressure after Fistfield is mounting, and they've got to find some answers.
And we also still after this presumptive legislation, Jess.
Yeah,
I mean,
that would be ideal, Tony, because you're dealing with people who have chronic and serious illnesses, so to flip the burden the other way would make it a lot easier for them.
I would have thought so. Also, the sad thing about this case is that the wife's also got cancer, so...
Yeah.
Anyway, look...
Just don't know why he didn't go in without breathing gear, though. That's also another issue for the CFA, whether, why they put him in without any breathing gear.
Yeah.
Who knows? Yeah. Anyway, viewers, we've got to go to a sponsors break. Stay tuned. After a break, we'll bring you up to date with insurance law and case law on that point. Viewers, welcome back to the show. Today we're going to talk about some current cases in insurance law. They're very interesting, but there's some very complicated facts in these cases. Jess, the first case of Powney and Kerrang and District Health, Victorian Court of Appeal decision of 2014. Can you give us the facts?
Yeah, certainly, Tony. So just by way of background, viewers, the plaintiff in this case attended the Kerrang and District Health Hospital for a procedure to his nose, effectively. And the point of contention in this case was that he was administered an injection which he says was unsterile and uncapped and caused him to develop an infection and permanent injury to his arm. And the second allegation I should add was that the nursing staff didn't respond to his complaints of pain in his arm, Tony.
And that was a major point of contention, wasn't it?
Yeah, exactly right, yeah.
Nunz, in the first instance, this matter proceeded before a county court judge and a jury of 6.
Yes.
What happened?
So it was before Judge Parrish and a jury of 6, and unfortunately for Mr Powney, he wasn't successful, and they found that Crane Hospital wasn't negligent in the circumstances.
Okay.
It was eventually appealed, which we'll talk about, but there was I think divergent opinion in terms of the facts and when things came on and when things didn't. So,
Jess, he developed septicemia from the unsterilised injection, right? Now, what was the evidence in terms of what actually happened during the procedure?
So the evidence was that the nurse had come into the room, Tony, with the needle on a tray, a kidney dish, and it was uncapped. And the client's, or the plaintiff's daughter gave evidence that it was uncapped.
How old was she?
She was 12 years at the time of the incident and 16 at the time of trial, which kind of led the jury, I guess, to draw an inference that it may have been unsterilised, but that was against the nurse's evidence as to her everyday practice in how she administers injections.
Okay.
So it's difficult balance to kind of weigh up those two competing stories, Tony.
So, Nunz, what happened? The jury came back with a verdict?
yeah, they came with a verdict, not negligent. And look, another issue though that I think was of a real substance was when his complaints, or if and when he complained about
that was very contentious,
his infection.
wasn't it?
There was argument too that he'd already been discharged after he complained, and that's when he went then back to the Bendigo-based hospital. But that was a big issue because nothing really came to light in the plaintiff's favour, and even the medical evidence suggested that the onset of symptoms would come out later after than he was discharged.
Well, there's a number of points of contention. One was the expert evidence. The doctors couldn't agree on when the symptoms manifested themselves.
Yeah, that was one point, Tony, and also the evidence as to, well, even if the injection was sterile and was administered correctly, there's still a risk of developing that infection.
Yes.
Which really kind of threw a spanner in the works, so to speak, for the plaintiff's case. And unfortunately kind of came to its head and the jury found against the plaintiff.
Now, he heavily relied on his daughter, and obviously the jury discounted what the daughter had to say.
Yeah. Oh, look, to be honest, I think that's fair. You've got a nurse who's trained in their situations, who would probably have a better recollection of what happened, as opposed to, with respect to a minor, a 12-year-old girl who wouldn't be keeping, I think, eye out for detail in that regard. So, look, I know if I was just the independent jury member, I know who I'd be believing.
Well, this matter went to the Court of Appeal, and the grounds of appeal were very technical, Jess.
They were.
It was in relation to interpretation of Section 51. 1 and 2 of the Wrongs Act. Can you tell us in simple language what they mean?
Yeah, so effectively, Tony, there's what we call a but-for test for causation, which is where the plaintiff needs to establish that the injection improperly administered had caused his symptoms effectively. And then there's another provision in the law that says in an appropriate case where we can't prove
the facts.
Facts. So, Tony, the provision in contention was whether or not in an appropriate case the jury can still find out negligence if the plaintiff can't prove that the defendant's conduct caused his harm, effectively.
In certain circumstances, maybe in cases where there's been infections and multiple infections.
That's exactly right.
There is negligence, but you can't prove the sequence of events, correct?
Exactly.
Now, what really hurt the plaintiff in this case, Nunz, is that his counsel didn't make the submission about the application of 51.2 until when?
Oh, basically the 11th hour, Tony. It was, I think, after before they were going to discharge the jury for verdict. So it was more of it felt like a fallback position. I think that's what it referred to in the
it was an
in
afterthought.
the judgment. It was. Look, I think it was a smart afterthought, but one that didn't ultimately prevail. So
what the Court of Appeal also said is that if you're going to argue against a but-for test and say that negligence should flow in any event, you should put in your pleadings. Which means what,
that's right.
Jess? What does that mean?
So effectively having it written in your statement of claim, which is your court document spelling out your allegations, Tony.
Or alternatively, Nunz, open your case with that.
Yes, right.
We say that you caused negligence and we'll prove that, or in the alternative, if we don't show it with you've caused negligence, we still rely on Section 51.2.
Ultimately, though, do you think the outcome would have changed if they were able to rely upon that section?
It's possible. I'm not saying it would have, but it was possible.
I think it would have been very difficult, though, to explain to a jury.
It would have.
Look, I think the same outcome would have prevailed, but,
it's hard to say.
hindsight's a beautiful thing.
Yeah.
It was a good ploy on the part of the plaintiff's lawyers because at the end of the day, they were really clutching at straws, weren't they?
Yeah. Yeah.
When the daughter's evidence went out the door, that was the end of the ball game, really.
Yeah.
All right, let's get on to this next case of Dunn, Mal and O'Sullivan. It's District Court of Western Australia. Nuds, what are the facts of this one?
Interesting case, yeah. So Mr. Dunmel was at Mrs. O'Sullivan's premises for a New Year's Eve function, and when he stepped out on the balcony with two other people, the balcony collapsed and suffered some pretty serious injuries, and that's really the cause of this action. There was an action taken against one, Mrs. O'Sullivan, who's the owner of the premises,
the property.
Two, the builder of the balcony, and three, the local council. And really interesting case, Tony.
And Jess, in this case here, she was involved in the building of the house, then she sold the property, isn't that right?
Yeah, that's
And then
right.
moved back again.
Yeah, that's right.
But
and the balcony was initially constructed some years prior to that, from my understanding.
and the court didn't find against the owner of the property, but did find against the other two parties.
That's right, yeah.
On what basis?
So effectively, Tony, the court looked at what duties should be imposed against the occupier, and it really came down to, one, what the cause of the breakdown of the balcony was, and two, whether or not she could have picked up on that occurring, so whether it was reasonably foreseeable, as we call it, prior to the event. And ultimately the court said, well, it wasn't visible to the naked eye, kind of undertaking inspections of the balcony, that it was going to potentially collapse, that the owner had multiple parties out there, and it just wasn't feasible for her to have building inspectors to come out every 3 to 5 years to inspect its condition.
And Nunz, they found against the builder because they used the wrong bolts. They weren't galvanised.
So, they weren't galvanised and they eroded, and then that was the cause of the balcony collapsing. And ultimately, there was expert evidence about all that, and that's why I think the builder in question was in the gun and ultimately was one of the liable parties.
Because the house was very close to water, so there would have been a lot of salt in the air. And
they would have to look at the building regulations back at the time it was built to see whether it was in contravention of anything, and I'm sure that would have prevailed. So.
Yeah.
Viewers, we've got to go. Sponsors break. Stay tuned. After a break, we'll take you up with a couple more cases. Viewers, welcome back to the show. We're talking about these very complicated cases. Nunz, what do these two cases highlight to you?
Two things, Tony. One, that it's important for every homeowner to have insurance. In this case, even though ultimately there was no negligence found against the homeowner, if she didn't and there was negligence found, she would have been up for a substantial amount of money. And it's just important that you take insurance out because you've got to be covered in these situations.
And insurance has got to be public liability, not just house insurance.
No, that's right, public liability, and look, it doesn't cost a lot in addition to your contents insurance, and generally it's for either $10 or $20 million worth of cover, and it's there, you don't have to worry about it, it's for that rainy day. So, and secondly, look, you've got to seek legal advice because these are really interesting cases, and you won't know,
as a plaintiff.
Yeah, you won't know whether you've got a case against the homeowner, the builder, the local council, the architect, or a range of parties, and really you need legal advice to sort through all those issues.
And Jess, the other point I'll make is this. Assuming you've got insurance, but you're failing to maintain, and that balcony was visible to the naked eye, then the insurance people will cut out, they won't indemnify.
Yeah, that's very possible.
So you've got to make sure that even though you've got insurance, if it's something that you're failing to do to maintain, then there's a chance that your own insurance company won't cover you.
Yeah, that's exactly
So it's very important. So in any of those circumstances, viewers, you should get advice from lawyers that know what they're talking about because, I mean, specialised again, isn't it?
That's right.
Yep.
Exactly right.
All right, let's get on to the next case of Vincent and Woolworths. Jess, give us the facts as briefly as you can. This is an unfortunate situation.
Yeah, well, Tony, in this case, a contractor was undertaking work stocking shelves effectively at Woolworths. She wasn't employed by Woolworths, but she was employed by another company. And as she was coming off a safety step, she collided with a shopping trolley that was being pushed by another customer in the store.
The vagaries of working in the supermarket.
Yeah, and unfortunately suffered some pretty bad injuries, Tony.
And Nunz, I just said it's the vagaries of working in a supermarket. What did the court find?
Well, basically they said, look, it's the supermarket's not liable where the relevant risk of injury was insignificant, and this was one of those situations. It's really something I think no one really could avoid. It's one of those things. What's important though in this case, I think that ultimately there was evidence that there'd been no situations similar to this nature before in that supermarket. I think it's important because if there was, there could have been a stronger case here. So it doesn't ultimately mean there couldn't be a case. No, that's what I'm saying.
Remember, you had your case where a young girl lost her sight,
Yes.
and they produced, records of how many people entered the club, and yet that didn't really.
Yeah, but I think the facts on that one were stronger for a negligence finding. But I'm saying even if it's an insignificant thing that could happen, if it's happened before, then you're on stronger ground. So it's something that you've got to ask the other side or the defendant as to situations that have occurred in the past.
Yeah.
Well, the court looks at reasonable foreseeability too.
Yeah, and that's what it came down to, Tony. They pretty much said that in this case it just wasn't foreseeable. And in a sense, I mean, it can go both ways in my view. I think it is foreseeable.
I reckon it is foreseeable.
In that it could
hasn't
happen.
occurred. Yeah. I reckon it's foreseeable you can have an accident, but it's not really likely to be a serious accident, but that's not the test.
And I suppose it's difficult for Woolworths to take steps to avoid that.
Yep.
So
you've
the court
got lousy
considered that.
drivers on the road, and you've got
Saying
lousy drivers in the supermarket.
Saying that, if she's doing the merchandising, you're cordon off the area. It's pretty cheap way of doing it.
Yeah, that's true.
They
That's a good
might
point.
need drivers' P plates for
for the trolley.
Anyway, let's keep moving. Forge and Atlantic Cleaning and Security Proprietary Limited. Another New South Wales decision of this year.
Yep.
Do you want to give me the facts, Mike?
So it's detailed, in short summary form though. Basically, this particular plaintiff was at Westfield Shopping Centre and then slipped on what's ultimately been caused like a greasy substance, and she knows that because when she fell onto her knees and hands, and she could feel the greasy substance on her fingers and hands, which is an important distinction later on.
It was described as clear, greasy, and slimy. Yeah.
So she slipped and fell and injured herself, and then ultimately there was footage of the accident, and which showed that a cleaner was in the vicinity 2 minutes before, and he's either not seen the substance that was already there, or two, he's cleaned it and hasn't done it properly. That's right. So either way, they were in trouble, and ultimately that was the finding.
Yeah.
Did the videos show him cleaning or not cleaning, or they didn't display that?
They showed him in the area.
Yep.
And then they gave evidence as to his type of cleaning and how he'd undertake cleaning of the area. So they agreed that the area he potentially cleaned was the same area where she slipped.
His evidence was he used some
blue cloth and just with his feet as well. It seemed very ad hoc.
Yeah.
But he also said he was rushing.
Yeah.
Because he had to finish his tasks.
Yes.
So
And
it
he
sounds to
said-
me he didn't do it properly.
Yeah, and he also said he didn't use any detergent. He'd just use a cloth, which in this case, I guess, was inadequate when you're dealing with the greasy substance, because it still remained there.
It was just a lesson. Sometimes you find these cleaning contractors are pretty fierce in their position that they've cleaned a relevant area properly, and that their cleaners will test that fact. I don't know, but this cleaner wasn't strong on anything, don't you think? He basically said, one, I'm rushing. Two, I just want to get my job done. I didn't put warning signs up. He basically gave a case to the plaintiff.
I reckon it would have been better off to say I didn't clean it, because then it would have been a case of, reasonable.
It would have come down to their system effectively. If he
because
said
once she's fallen over, it's almost a case of raise zips or lock it up. You've cleaned it, but you haven't done it properly.
But her evidence that she remembered it being greasy was really important. That's why when we speak to plaintiffs and we tell them exactly what do you recall on the day to the nth degree, they're the important facts, because if you're believed on that, that can win you the case.
And also that's why you want them to keep their shoes and clothes.
Yeah.
Because, if they've slipped over and you can't actually see the substance, but it's then all over your trousers or skirt or whatever, keep that, because that's the evidence in terms of what was on the floor.
Exactly right.
Correct?
Yeah, that's
and you can get it tested.
Right. Yeah.
Do you know what was also interesting in this case, Nels, was that she had two subsequent falls?
Yeah, that complicated the case. So she's had two other falls, and I think one was at Westfield again, and then one was at work as well. And one was to the same injury, which is, I think, is the right knee, and so that complicated the apportion of damages and how do you apportion what pain is attributable to what injury. And ultimately, the judge had to make a finding, and he discounted accordingly.
But also the judge found that because of the fact that she had two subsequent accidents, it sort of went to her credibility in her favour.
Yeah.
Because she didn't sue for those.
That's right, and in the sense that she continued working, Tony. So the judge was highly commending the plaintiff for that.
And she got in total $65,000.
65,000 and 20,000 of it was for pain and suffering. So look, it seems a
Didn't get a
little
lot for
light.
her
It seems a little light,
troubles,
but you know, ultimately there's
Didn't get a lot for her troubles, did she?
yeah. So
Nunz, anything else you'd like to say before we clock up?
no, just a lesson to plaintiffs and you know and clients. You need to see a lawyer because these are important facts, and you need a lawyer to sort through those issues.
Thanks, Nunz. Jess, thanks for coming on board.
Thanks for having
Viewers,
me,
stay
Tony.
tuned for future episodes. Go to our past episodes. Go to all our social media platforms. And always remember to stay safe.